Legally Speaking with me, Tarun Nangia. In our series on Justice Chandrachud, where he has taken a decision that 10 bail matters would be listed before each bench on a daily basis, gives a lot of hope to the whole investors community, which is looking at India very closely, because liberty is at the heart of, in a sense, a democratic society. But also liberty is at the heart of a capitalist society where people need freedom of movement. You can't have businessmen languishing in jails for 10 and 12 months or 1.5 years before they end up getting bail. But when Justice Chandrachud has taken a decision that so many bail matters will be heard daily, of course, there is a lot of hope. Secondly, one must not forget his message to the subordinate judiciary, where he said that that they're hesitant to give bail, and that shouldn't be the case. A good message went out from him to understand the real impact of these decisions. I have a very eminent panel with me. I have with me Senior Advocate Seshadri Naidu, who joins us from the city of Delhi. Good to see you, Mr. Naidu, and looking forward to some interesting inputs from you.
Thank you.
I have with me Advocate Rohan Shah, very well-known name in the field of tax and financial matters, appears before the Bombay High Court, the Delhi High Court, and the Supreme Court of India, including tax tribunals. Good to see you, Mr. Shah. Looking forward to some interesting insights from your end as well. At the outset, may I request Senior Advocate Naidu to make the opening comment before I go to Mr. Shah. Over to you, Mr. Naidu.
Well, the universal problem Indian judiciary faces is the explosion of dockets and the mounting pendency. And where do we find the solution for that one? Every successive chief justices have been trying their best to address this issue. It's a deeper malady. But as far as the court is concerned, be it the Supreme Court, be it the High Court, or whichever, as the famous proverb goes, we don't have this sword or purse. We just have the pen, nothing else. So institutional inadequacies apart, well, now the Honorable Chief Justice of India has taken a very wonderful step that every day there should be mandatory listing of a few cases when it comes to, say, bails which involve personal liberty, and also transfer applications. Mostly they concern matrimonial disputes. I think they have to be done that way. But before that, there is another problem. How come the apex court has been flooded with the bail applications, which could have been ending at the level of another constitutional court, say, High Court? In our constitutional dispensation, they have been treated as on a par, unlike the American Constitution, where there is one Supreme Court and all other courts, including the circuit courts, likened with the high courts, are inferior. But it's not the case here. Perhaps the buck must stop at the High Court level unless there are exceptional circumstances for the Supreme Court to interfere. It is a question of discretion. And now, when it comes to discretion, the scope of interference must be very limited. You may have a different take on an issue. I may as well have another one. Just because we have had a different views possible, would it be paving the way for just clogging the system? This is the problem we have been facing. So that has to be addressed. Means, in a sense, I don't know whether if I could tell that, perhaps it's time the Honorable Supreme Court has focused more on rather a deeper and more ponderous issues, such as involving constitutional nuances, rather than the mundane matters of all these things. Yes, I do agree when it comes to bail, it's a question of liberty. But at the same time, it's a matter of discretion as well. So I believe that the high courts must be given a free rein on that count. And once that's been the case, maybe perhaps it will have lesser of a burden and more of a time to deal with rather important issues. This is what I feel when it comes to that.
Thank you. Thank you so much for that comment. And let me qualify that before being a senior advocate, the Supreme Court Justice Seshadri Naidu has also served as a High Court judge in the Bombay High Court, also in Telangana High Court. And that gives that perspective that he comes from. Having served, of course, he understands the issues of the system, and that's how he shared this comment. May I request Advocate Rohan Shah, who's done some study on this subject, not on this bail issue, which but also on the larger issue of pendency. Over to you, Mr. Shah. You're not audible.
Yes, unmute.
Yeah, sorry. Thank you, Tarun. And following on from Mr. Naidu's comments, I think this issue in terms of bail really goes to the heart of the issue of the respect in the Indian system in terms of life and liberty, right? And as you sit in court, or even as the media sort of follows these issues, often you get brought to the notice of the public situations in which an under trial is sort of faced jail time even beyond what he would have faced on sentencing. And an issue like that is obviously an issue which creates a very fundamental issue in terms of the justice dispensation system, and the factor that if people are to suffer jail terms in this manner, then what is the real concept of life and liberty in the Indian context, right? Now, one part of this, Tarun, as you framed in the earlier part of the debate, was what is the impact, issues like this may have on investors. And while I think it does have an impact on the investing community, particularly in a phase where responsible investing is now the overarching theme, drawing from the whole ESG, which is, your environment, social causes and governance, people are going to be concerned about the systems of law and the systems of administration into which you invest. So I think it clearly has an impact on investor sentiment, but much larger, I would think, is the sort of accountability that many public institutions and multilateral institutions hold us to. So Amnesty International, Red Cross, etc., who monitor these issues in the context of really, A, the rule of law, and B, in terms of the quality of life of citizens. And I think this initiative is really just an outstanding initiative because it goes to the very heart of this issue of saying that if somebody deserves bail or deserves not to have bail, that is not a question which should be left pregnant in the legal system. That's a question that the court need to deal with. Like was said earlier, maybe this should not gravitate up to the Supreme Court. But in the case of these 2,000 or 3,000 cases, this has gravitated up to the Supreme Court, and it is inevitable that the Supreme Court deals with it. And the fact that it is being dealt with on a day-to-day basis on priority, I think, very clearly goes to A, indicate a much more empathetic justice delivery system, and B, very clearly also brings center stage liberty, which is clearly one of the pillars of our whole constitutional scheme. So to my mind, giving primacy to this so early in his term really sends out a very, very strong signal, internationally, in terms of the quality of the democracy and the sort of protection and process of law that we offer our citizens, and takes away what I would think is been a matter of some criticism, not only internationally, but even domestically. And undoubtedly, this is something which will have a positive impact in terms of our growing stature as not only economic power, but really a sort of democracy that the world looks up to.
Okay. Point well taken. I'll go across to Justice Senior Advocate Seshadri Naidu. Mr. Naidu, I want to request you to tell us one thing. The reluctance of lower court judges to give bail and the message given by Justice Chandrachud, the Chief Justice of India. Where do you think, what was he aiming at, in a sense? What message that he was trying to give via his, in a sense, statement?
Well, all along, it's been an accepted principle in judicial arena that hierarchy is only administrative, not judicial. A judgment by the lowest echelon of the court, say a magistrate, is as powerful and as binding as that of the highest court, there's a Supreme Court. So it's time, perhaps, in the view of the Honorable Chief Justice of India, even the nomenclature must change. I tell you, the other day, I just was watching, or rather listening to a debate in BBC radio. In that one, we talk about the master bedroom, right? It is, in fact, coming out of the slave trade. When the black people are there and the master of them being the white man, he would be occupying the important room in the house that could be called the master bedroom. So these hangovers still are there. They have to be washed off. In that sense, the Honorable Chief Justice must have said that one. The nomenclature, they're the foundation, they're the pillars of the judicial system, dispensations. That's why calling them subordinate judiciary or lower judiciary may not be the right thing. Accepted. That's why the adjudicatory echelons, nothing like one court is superior when it comes to rendering the judgment, unless it's been taken in the context of constitution or the statute in appeal. Otherwise, they're all on an equal footing. Administratively, yes, the tweaking will be there. The other systems could be there. That's why. But there is another thing that touches me wrong now, because when it comes to, say, for example, bails, we have got individual perspective, and the other one is institutional perspective. Right. So what I would like to say is, individually, as we call it in legal analysis, it's ex post approach. That means something has happened. Perhaps I've been arraigned as an accused, so I need the remedy. Please provide it to me. This pre-conviction incarceration must not be at the order of the day. That's the perspective individually. Let's take institutionally. Yes, there's no denying the importance of individual liberty, and more so in the context of constitutional courts, vis-a-vis the bails, arrest, etc. At the same time, 130 crore people, there is one Supreme Court sitting in panels of each 2 or 3, maximum 13 to 15 benches. How many cases could they think of handling? You take the example of American Supreme Court. There are 9 judges, they sit en banc, and they decide on average 70 cases a year. And each judge would have the opportunity of writing 3 or 4 judgments, at maximum 5 to 10 judgments. Whereas each Supreme Court judge, rather each Supreme Court bench, would be churning out about a dozen judgments every day. Each bench, most of them are reportable. So my view is they've been overburdened. So it's time. There is trust in the institutional setup. Where it has to stop, it has to stop there. Trust the high courts that they can do their job. In that sense, earlier, when there is any observation in a judgment or whatever, it was confined to the realms of judicial reports, the journals, only read by the lawyers and others. Now, thanks to social media and access to information in every imaginable way, whatever a word that's been uttered that may have at times quoted out of context, a chilling effect. And that's why the intellectual freedom has been restricted. And more so now, I believe, as I was once an insider, I could say some of the judges have been forced to play to the galleries, saying that if I write the judgment, what's the comment on the social media? That's the dangerous trend we are facing. And sometimes quoted out of context, then what happens? I believe that every institution may have its moments of glory, moments of shame. Every individual may have that one. You take the most quoted American Supreme Court judge, Oliver Wendell Holmes. He has said many things which are not acceptable to us. When there is a forced sterilization, he said 3 generations of imbecile women are enough. Can we accept that one? But still is one of the greatest judges. Sometimes an intellectual may make a mistake, but that doesn't mean that he has to be castigated or punished in the public and put to shame. So now the High Court has been facing this fear psychosis. And that's why that institutional deference has to be, of course, to a great extent it's been there. I reckon that it should be on the move.
Thanks. Thank you for that comment and, laying out the issue threadbare. I'll request Mr. Rohan Shah to address this from this perspective. For example, a certain, case has been made out, or, the prosecution leaks some news item which says 22,000, 25,000 crore scam. When the charge sheet is filed, the allegations, the numbers in the charge sheet are like 50 and 60 crores. So the news item mentions 20,000 crores. The charge sheet said 60 crores. But when the businessman goes for bail, do you think the courts are unduly pressured by such big numbers that are leaked to the media that it becomes unsaid pressure against giving bail? What do you think of media hysteria and the whole issue of bail, and what improvements need to be done?
I think the Honorable Chief Justice was, absolutely right that in high-profile matters, and particularly matters where the economic dimensions are many and the amounts involved are extremely high, there is, in any case, an inherent pressure on the lower judiciary, and I think throughout the judiciary. Now, that undoubtedly in this day and age gets magnified manyfold by the impact of the social media and also by the impact of the electronic and the print media. Because, if you see even the front page of the newspapers, almost every newspaper carries a specific column of what happened in the courts today. So therefore, what happens in the courts now is equivalent, if not more reportable than what is happening, for example, in the PMO, or what's happening in the Ministry of Finance or in the Ministry of External Affairs. So given the amount of high-profile matters which are there, and given the magnification of issues which you get in the media, and of course, the media magnification is twofold, right? One, pre-hearing and post-issuance of decision. So really, if you are concerned about media, then you're concerned about the pressure that is created prior to a hearing and the criticism or comment which is likely to come post a hearing. Now, to me, this is important from two perspectives. One, the enormous pressure that it places on the lower judiciary, and which I think caused the comment of the Honorable Chief Justice that many of the judges feel pressured, in issues like this, and maybe a little hesitant to sort of give bail. And the sum total of that is that all this really escalates up to the High Court and then to the Supreme Court. And in all the high-profile matters, you essentially end up in the Supreme Court. Now, the impact of this is not only being felt on the lower judges, our judges in the subordinate judiciary. I think the impact of this is also felt in the bureaucracy, because even bureaucrats are hesitant to take decisions on issues before them if they consider them high profile or if they consider them sensitive. And this again becomes a situation of matters escalating up to the Supreme Court. Now, I think the need of the hour really seems to be that if a Supreme Court is to play the role originally envisaged for it, and the whole of the justice delivery system needs to sort of ease out in a manner that the common man has justice at all levels, and the Supreme Court is able to focus on the larger constitutional social issues, then it's very, very important that without fear of either media or castigation or comment, judges in the subordinate judiciary, bureaucrats in their own role, are able to take decisions and are confident that those decisions, if taken in the right bona fide manner, will not be subject matter of criticism. Because as was said earlier, yes, all of us exercising a set of options intellectually could make a right or wrong decision. But the moment aspersions are cast on it, the system freezes. And the system freezes, the lower judiciary or the subordinate judiciary judges freeze, bureaucrats freeze. The sum total of all of that is a completely flooded Supreme Court, which has to spend time literally playing the role of arbiter on every issue which confronts individual, institution, government, or society. And I think that's a very, very unfair burden to place on the Supreme Court.
Point very well taken. I'll take this question to Senior Advocate Seshadri Naidu. I want to ask you, sir, two things. It is one good thing that Justice Chandrachud has given out this message. Tell me, say, over 1 year, with 170, 180 cases being heard every day in the Supreme Court, do you think a huge relief will indeed be felt by the litigants? Because this is a time when we saw a lot of businessmen going to jail in the past, say, 7-8 years. A lot of businessmen have gone to jail. And of course, bail is one of the most important issues that is discussed, when you speak of liberty, that, bail not jail is the principle, as also what Justice Krishna here had said.
Well, it's confession time for me. When I was a High Court judge, people are asking me, what would you do on Saturday and Sunday? and they would complain, you're all like school children, you will have many, many holidays. I have told them that there is no Saturday and Sunday for a judge. Holiday is only to recharge ourselves intellectually, not to holiday out. After coming over here and practicing, I have realized the burden of a Supreme Court judge is manifold compared to that of the High Court judge. I do agree that High Court judges work hard, and the Supreme Court, the burden is supreme. More so, they just groan under the fear that being the final court, a small mistake could be fatal, that could be changing the fortunes of the people. That always hangs on the mind of the judge in Supreme Court. This is one thing. And the burden that's been cast on them is very huge. Maybe a forward-looking Chief Justice of India, like the Honorable Present Chief Justice of India, Dr. Chandrachud, he perhaps would think of one system where you take an American jurisprudence, there a time limit has been prescribed for arguments. UK, again, time limit has been prescribed. They're small countries compared to us. Why not we have a matter petering on for days on end? How about the other people? They're waiting in the line for many, many years. But indeed, given all other things, on the same footing, yes, the adjudication in Supreme Court is very, very, very fast. I agree. But still, there is room for improvement. Maybe it's time some proactive steps have been taken, and the whole system has been streamlined when it comes to oral arguments. Here, a person like Lord Denninger said, when it comes to the judgments, why should I write everything that of the lawyers mumbo jumbo? They are there as amicus to help me to arrive at a decision. I'm not a mere arbitrator just to hear both sides and choose which is the better. No, they are only facilitators. They are rightly called the officers of the court. In that sense, yes, Supreme Court could have some measure, at least in the apex court level, to cut short the litigation or the delays, that there should be a time cap on everything. Let them submit written submissions, and then they could be perused by the court, summarized with all your articulation could be used for that purpose. But one case taking a week, a case taking 3 weeks, I don't think we have that idyllic pleasure anymore.
Thanks for that comment. I'll go across to Advocate Rohan Shah to ask him. A good beginning has been made. What you look forward to from here on? Because I think barely within a fortnight of taking over, Justice Chandrachud has given us this very good decision. And, it's brought a lot of hope to people. As we said, and you were a part of that series that we did on Justice Chandrachud, we titled it Hope. And that hope seems to be turning true. In my next show, we want to take up the indirect tax bench, which is one of the other important things, very important thing that he's done. But that's for another show. Your comment on that?
Muted.
Yeah, sorry. I think he's a Chief Justice who's come with, literally a sea of hope across every stakeholder in the judicial system and, even the governmental system. And I think the steps already taken in the first few days very clearly indicate that, we are in for some very far-reaching changes. And I think the one thing which, again, is going to democratize the whole process of being in the Supreme Court and participating in the Supreme Court as a litigant or as a lawyer is the whole process that, if we would move full-time to the ability to do hybrid hearings, that is, you could address the court either virtually or in person, because what that does is it brings in a much wider spectrum of legal talent who can address the Supreme Court. The pressure that we just now see on many of the leading seniors, the resultant issues that we see in terms of adjournments, you de-stress the system in relation to something of that sort. And as was said by Mr. Naidu, the whole situation in terms of shorter pleadings, shorter arguments, and the last thing I would look at, which is not in the Chief Justice's control, but I think the government should take that step. Government needs to be a more responsible litigant. If these four factors come together, the ability to address the court electronically, the time-bound hearings, pleadings which are pithy, and a little better control in terms of government as a litigant, I think the impact of all of those factors would be very, very far-reaching.
Thank you. Thank you for that comment. And indeed, really interesting times during the Chief Justices of Justice Dhananjay Chandrachud. Very big decision of hearing 10 bail matters every day, also 10 transfer petitions, and a very positive message that has gone out to the entire community of which looks at India as a business destination. They look closely at all these things, and we can all safely assume now that Supreme Court doing a lot to ensure that the Indian economy continues to grow. As we have said, the ministers of this government also earlier had said that the courts also have a responsibility to ensure the economy grows, and they can do this by faster disposal. Of course, looking forward to our next show on the direct and indirect tax issue, but that's sometime, I think, a couple of days from now. Thank you so very much. I would like to thank Advocate Rohan Shah, Senior Advocate Sheshadri Naidu for making time and joining us on this really important issue. Thank you viewers for tuning in. Thank you so much.
Thank you, Tarun, and thank you, Rohanji. Thank you very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.